Okay, good afternoon, everyone. Welcome to the State Ethics Commission Zoom webinar. I'm going to do a quick check on how many folks we have joining at the moment, and if we have a sufficient number, we'll go ahead and get started. All right, great. So it seems like we have over 52 attendees at the moment, which is plenty for us to go ahead and get started. So we'll start with some quick introductions. I'm Jeremy Ferris. I'm the Executive Director of the State Ethics Commission. I'm here on the Zoom today with Walker Boyd, who's the General Counsel. And though you can't see him, Sunny Haqqani is ensuring that we don't get Zoom bombed as we go through our CLE together today. Before we start, I just want to go through some housekeeping materials. The first is, if you can only see a giant screen share on your screen, and the State Ethics Commission's PowerPoint is dominating your screen, if you just press Escape, you'll be able to minimize that screen and look at the meeting materials or email or our talking heads. Second, you should by now have received the meeting materials, but if you haven't, if you click on the link in the title screen here, sec.state.nm.us, or navigate to that web page and click on Transparency and then upcoming trainings and CLEs, you can download the Zoom webinar materials right there in case you don't have them on hand. Third, there's we are providing a CLE here, so when you registered, you should have been prompted to enter your bar number. There will also be a form after the CLE where you can input your bar number. And if you want to make dead sure that we have your bar number, you can email it to ethics.commission@state.nm.us, and we'll make sure you get the CLE for this webinar. So before we jump into it, I want to just begin with some thank yous. I want to thank Secretary Ortiz at the General Services Department for distributing this webinar and the information to the Risk Management Division and Risk Management Contract Counsel. And I appreciate all of the risk management attorneys and contract counsel attorneys that have joined us today. We also have several members of the trial attorneys who have joined us today as well, who might take an interest in representing complainants in cases before the State Ethics Commission. We have legislators on the webinar with us. We have the State Bar President. So I'm just very pleased in the attendance today, and I hope this will be informative for you. And then with that, Walker, I think we can get started with the actual CLE. So we'll start with the Commission's powers as an administrative agency. We learned from junior high school that the governmental functions are divided into three kinds of powers: the executive power, the legislative power, and the judicial power. That's how the federal Constitution is structured in its first three articles. And as lawyers, we're taught that there's a separation of powers between the different branches. And in fact, in the New Mexico Constitution, Article 3, there is a separation of powers clause. The interesting thing about administrative agencies is all of those powers kind of get combined and rolled into a single entity. An administrative agency can almost be a microcosm of the state, in that there are different kinds of powers that get vested with administrative agencies. And the State Ethics Commission certainly has that attribute. So here on this slide, I'm just going to quickly provide an overview, kind of from a powers perspective of what the State Ethics Commission does and has been authorized to do since January 1st of 2020, when the jurisdictional provisions of the State Ethics Commission took effect. So there's the Ethics Commission, like several administrative agencies in the federal and state system, has a quasi-judicial kind of power. It adjudicates administrative complaints that are filed with it. And this is kind of the posture of complainant versus respondent in the State Ethics Commission. Proximate to that quasi-judicial power, the Ethics Commission also issues advisory opinions. And under the State Ethics Commission Act, the advisory opinions that the Ethics Commission issues can be used defensively if a respondent has relied in good faith upon a prior issued advisory opinion. The Ethics Commission will credit that defense in an administrative adjudication. So those are the kind of the quasi-judicial functions that the Commission has. The Commission also has a kind of range of executive powers. Foremost among them is the power to investigate and initiate civil litigation in state courts to enforce the statutes for which the Commission has jurisdiction, or the laws for which the Commission has jurisdiction. And separate from the posture of complainant versus respondent in the State Ethics Commission, this is in the posture of State Ethics Commission versus defendant in a particular court, depending on what venue provision applies. Alongside that very large executive power is other normal executive functions that the Ethics Commission does. The Commission can provide recommendations on amendments to New Mexico's ethics laws to the legislature. The Commission can offer ethics trainings and guides, much like we're doing right now. And then third, the Commission has a delegated kind of legislative function, a legislative power that comes down to the Commission through its rulemaking powers that are delegated in the State Ethics Commission Act. So the Commission has the rulemaking power to promulgate rules of procedure, which we'll be going over today, and also the rulemaking power to issue a proposed code of ethics for other state agencies as they issue their own codes of ethics and codes of conduct. So very broadly, that's a broad overview of what the State Ethics Commission does from a powers perspective. So Walker, if we could move on to the next slide.
Really quickly, before we do that, Jeremy, I just want to let the listeners and participants know that there's a Q&A function in the Zoom software. So if you're joining by computer, you can submit questions, either associate them with your name or submit them anonymously. I'll be trying to monitor those questions as we go through, but I think the approach that Jeremy and I are going to be taking is to have those questions answered at the end of the webinar as time permits. So
thanks for that, Walker. Yep.
If any questions come up about what's on the slides or what Jeremy or I are saying, go ahead and submit a question in the Q&A box.
Yep. And if it's urgent, Walker will let me know and we'll tackle it. All right. Next, so we're kind of zooming in on the main meat of the topic of today's CLE, which is the laws that govern administrative complaints that are filed with the Commission and how they're adjudicated. But before we kind of get into the law, I want to talk a little bit about the theory and some kind of larger perspectives for what the Commission is doing in this project of issuing its administrative rules and try to kind of foreclose some frustrations that might come up, or just give you a perspective if you litigate a case before the Commission on what's going on. So first, this point about efficient gaps and gap fillers. In the very first case book that was ever kind of prepared for law schools all now use case books, which are collections of cases. You're all well familiar with them. You have them sitting on your bookshelves behind you. Christopher Columbus Langdale put together the first contracts case book. And in the preface, Langdale referred to the law as a seamless web that applies, as he said, to the ever-tangled skein of human affairs, that the law would apply ideally without any gaps. That might be a nice 19th century formalist view of how the law works. Unfortunately, it's not true, and it's certainly not true of the Ethics Commission's rules of procedure. the rules of procedure that the commission promulgated in a rulemaking late last fall contain a lot of gaps, and they do so intentionally as a matter of efficiency. So if you were to compare just 1.8.3 INMAC against the federal rules of civil procedure or the state rules of civil procedure, you'll notice that it's much shorter. That there's a lot of kinds of rules, that procedural rules, that the Ethics Commission doesn't have. For example, there's no rule on amendments of complaints. There's no rule on joinder. There's no rule on service of process. And that again is the administrative agency, the commission is trying to do something that's slightly more efficient in the way that it adjudicates complaints that are filed with it. Now we do have a kind of gap filling function at 1.8.3.8 standing orders. So if we run into a gap that's a real problem for the commission, and the commission can't fill the gap with a rulemaking, the executive director can issue a standing order to fill the gap. And the Administrative Hearings Office has a similar kind of gap filling rule in its rules of procedure at 26,601 INMAC. And essentially the level of detail that we were driving toward is similar to the Administrative Hearings Office or the Human Rights Commission of their rules. So know first that when you're litigating a case with the Ethics Commission, there are a lot of gaps, and the gaps are ordinarily filled by discretion and informed by briefing, and that's purposeful. Second, I want to talk about this point about what I'm calling administrative non-delegation. So this is not the traditional non-delegation doctrine, which was applied by the Supreme Court in 1935 in Panama Refining and Schechter Poultry. That's the long discarded theory that Congress can't delegate its legislative power. That doctrine has been interred. It's really no longer vital, although some members of the current court are attempting to resurrect it. This idea is a separate idea. It's the idea that once the legislature delegates powers to an administrative agency, the administrative agency cannot further delegate those powers to someone else if that power is quasi-judicial, if it involves the exercise of judgment. So for example, the State Ethics Commission couldn't delegate to the executive director or the general counsel the power just to go ahead and adjudicate an appeal from a hearing officer order. So this particular doctrine that in New Mexico case law comes up in the Weinstein case and in Kara-McGee Nuclear Corporation, this pretty much means that the rules were crafted to where dispositive actions have to be conducted by either the hearing officer or the full commission. And so that creates a kind of inefficiency that runs a little counter to our efficient gaps thesis in the rulemaking. So if you're litigating a case before the commission and you come across a notice that the director has recommended a case for dismissal for lack of jurisdiction, or the general counsel has made a recommendation to a hearing officer on a motion to dismiss for failure to state a claim, that's because as the rules were promulgated, the executive director and the general counsel does not itself have the power under the statute to do the dispositive action. That has to be done either by a hearing officer or the full commission. And I'm very proud to say that the Ethics Commission now has a couple of arrangements for hearing officers. We have a contract with Justice Chavez to provide hearing officer services, and we also have a memorandum of understanding with the Administrative Hearings Office to provide hearing officer services. So again, dispositive actions are taken by hearing officers or the full commission because of this doctrine in that case law. And then last, there's a really an overarching point here that the commission is very new. It started jurisdiction in January. We promulgated rules of procedure late last fall to be ready for jurisdiction to begin in January, but it's still very much an experiment, much like what Justice Holmes set of the Constitution and of life. It's all an experiment. And the test of the commission's ability to adjudicate complaints that are filed with it will be worked out with you in briefing and with us. But I also want to point out that in New Mexico administrative law, there's a way where if you really believe a gap needs to be filled, rulemaking doesn't begin with the commission alone. Under the state's rulemaking rule, the default rulemaking rule at 124.25 INMAC, members of the public can initiate agency rulemakings by filing a petition. And if you see a real gap in the commission's rules that you think needs to be filled by way of rulemaking, you're always entitled to file a petition for rulemaking, and we would encourage you to do so. So that's the kind of the broad theory, the efficient gaps hypothesis, the administrative non-delegation doctrine, and the core kind of American pragmatist idea that this is all a great experiment. So prescinding from the theory, the law that governs this area is sections 1016 G9 through 12. That's the State Ethics Commission Act, 1.8.3 INMAC, in the Administrative Code, and 5 separate contracts that the State Ethics Commission has entered with the Secretary of State and the State Purchasing Division for how shared jurisdiction for various statutes will operate. So that's an overview of the theory and law. And Walker, if you could take us to the next slide. Great. So this is basic. This is how it gets started, how to file a complaint with the Ethics Commission. On our website, we have a complaint form as the legislature instructed the commission to create. And when filling out the complaint form, if you're advising a complainant, you have to include the respondent's contact information. When the legislature enacted the State Ethics Commission Act, it put the burden of service not on the complainant, but on the commission. So you have to tell us the respondent's contact information so that we know who to serve with the complaint. A complainant has to tell us. And if the complainant does it, we'll dismiss the complaint without prejudice and entitling the complainant to refile once they have the respondent's contact information. Second, the complaint has to be signed. It has to be notarized. The legislature included notarization requirements that's interesting and creates a small administrative hurdle, I think, for complainants that want to initiate complaints with the commission. Attaching additional pages or exhibits as necessary. We don't have a limit, and a lot of pro se complainants have attached very voluminous amount of pages for us. And then finally, you can just submit the complaint to ethics.commission, or you can mail it to us at our mailing address for now. But I want to alert you to the fact that we are now attempting to build a software, a web-based case management and docketing system. The hope is to build something that's more user-friendly and more streamlined than Odyssey or Oscar. And our hope is that it will be very user-friendly. It's being developed by the same company that helped us with our website, which is a very good company. And very soon we'll get it into testing phase, and hopefully by later this summer we'll roll it out for members of the public. So that's a rough overview of filing a complaint with the commission. So next, turning back to a kind of a grand view of the statute and the rules for how these administrative cases will go. A complaint is filed. The executive director under the statute has the burden to determine jurisdiction. If a complaint is within the commission's jurisdiction, the complaint will then carry over to the general counsel, who roughly conducts an investigation to determine if the complaint is supported by probable cause or if it's frivolous. If the complaint is supported by probable cause, at that point, a hearing officer is assigned, either, again, Justice Chavez or someone on staff at the Administrative Hearings Office. And the hearing officer will conduct an evidentiary hearing and issue final rulings. The hearing officer's orders can be appealed to the full commission to the 7 commissioners sitting as an appellate body. And there's no right of appeal to the state courts from commission decisions. If you're representing a party who did not prevail before the full commission on appeal, you have to petition a state district court under Rule 75 in MRA for certiorari for review of the final administrative agency action. The Ethics Commission doesn't fall within the state's Administrative Procedures Act. It sits separately, and so there's no right of appeal to state courts of final commission decisions. That's the brief view in 5 acts. And here's our wonderful little graphic that explains how cases proceed in the State Ethics Commission. As you can see, the public compensates us for our legal abilities and not our graphic design abilities. So, you guys like that? Great, easy room. All right, moving on. So, the commission's jurisdiction. So reaching back to civil procedure and the distinction on different kinds of jurisdiction that a court or an administrative adjudicatory agency has. So the commission's personal jurisdiction, these are the individuals and entities that the commission can bind in its orders under its delegated jurisdiction under the Constitution, Article 5, Section 17, and the State Ethics Commission Act. So it's all statewide elected officials and legislators, all the employees of the legislative branch and the executive branch, roughly. All lobbyists who are registered with the Secretary of State and the employers of lobbyists. All candidates and other entities that are subject to the Campaign Reporting Act, and all state government contractors or seekers of state government contracts. That means entities that have responded to an invitation to bid or a request for a proposal. That's a very large personal jurisdiction for the Ethics Commission, and the commission has to, its rules have to be transubstantive across all of those different kinds of cases. It has to work for all those different kinds of cases, and eventually the commission has to have the capacity for a large volume of complaints for all of these, for this large range of personal jurisdiction. And hopefully part of that capacity will be enhanced through a very clean and streamlined case management and docketing system. So flipping over to subject matter jurisdiction, these are the laws for which the commission has subject matter jurisdiction. The Campaign Reporting Act, the Financial Disclosure Act, the Gift Act, the Lobbyist Regulation Act, the Voter Action Act, very importantly, the Governmental Conduct Act, the Procurement Code, the State Ethics Commission Act, and Article 9, Section 14 of the Constitution, which is the Anti-Donation Clause. There's a lot to say about the difference among these laws and the different kinds of claims they create, and we'll get to that. But at the moment, this is the kind of subject matter of jurisdiction of the commission. Now, I will say that the commission every year is charged to provide the legislature with recommendations on amendments to its own jurisdiction, either its personal jurisdiction or its subject matter jurisdiction. And looming large on the horizon for potential amendments to the commission's jurisdiction on the personal side is whether the commission's personal jurisdiction will ever be expanded for local governments, for more precisely the officials or the employees of local governments around the state. And you could think of a number of statutes that are proximate, or constitutional provisions that are proximate to the laws listed here, that it might make sense for the commission to have jurisdiction over. For example, the two emoluments clauses of the state constitution, or the Whistleblower Protection Act, for example. But this is part of the experiment. And by October 2021, the legislature charged the commission with providing a report on particularly that large question of expansion of personal jurisdiction to local government officials and employees.
So can I jump in really quickly, Jeremy? We've received a couple of questions here, and I think probably in the interest of efficiency, it makes sense to answer them now. One asked about whether the commission has jurisdiction over local government officials. I believe you just kind of touched on that in terms of contemplated expansion of the commission's jurisdiction, but I think to underscore that point, we do not currently have personal jurisdiction over local government officials under the State Ethics Commission Act. Anything to add to that, Jeremy?
No, not at the moment. I will touch on that in a second when we get to the constraints on jurisdiction slide. Okay,
and then someone asked if the commission has jurisdiction over the Secretary of State and the Secretary of State as an elected official. Would you like to answer that?
The answer to that question is yes. The Secretary of State falls within the commission's jurisdiction.
Okay, thank you. I think that's all our questions for now.
All right, thank you for those. And then moving on quickly to the process by which the executive director of the commission under the current statute and rules would review for jurisdiction. So the commission staff receive a complaint. The first thing that we do upon receiving a complaint is provide notice to the complainant that we got the complaint, and notice to the respondent that a complaint has been filed against them. If the respondent is an employee of the state, we will also send the respondent a letter from the Risk Management Division of the General Counsel, or the General Services Department, and indicating to the respondent that if they believe they're entitled to representation by risk management or risk management contract counsel, to reach out. And we provide that notice within 7 days. The respondent can then answer the complaint. The respondent can also file a motion to dismiss. Under the rules, again, this is an example where the commission's rules of procedure are more limited than the rules of civil procedure. So the respondent can move to dismiss for lack of subject matter jurisdiction or the lack of personal jurisdiction, or they may file a motion to dismiss for failure to state a claim. So essentially, that's a 12B1 or a 12B2 or a 12B6 kind of motion. The complainant can then respond to that motion, and then the executive director, if it's a 12B1 or a 12B2, a motion to dismiss for lack of subject matter or personal jurisdiction, the ED will make a jurisdictional determination in a letter ruling, but again, that letter will be phrased in the form that it's very likely that the commission will dismiss your complaint for lack of jurisdiction, but the dismissal doesn't actually happen until the commission can get to it in an open meeting of the full commission. And I'll also note under the rule in the statute, that's not the ED's determination over jurisdiction is a matter of statute. It's not as though the commission has the power to second guess the ED on jurisdiction. The statute accords that wholly to the ED, but again, the ministerial act of disposition has to occur in the commission. That's our best reading of the statute across a few sections. And then if it's dismissed, again, the commission will do that, discussing it in closed session, and then making a vote in open session. Thanks, Bob. So there are a number of constraints on the commission's jurisdiction that you should bear in mind when filing a complaint. One class of those constraints follows from the bedrock principle in administrative law that administrative agencies are limited to the authority expressly granted to them, normally by statute or necessarily implied by statute. The Ethics Commission is a little different in that it's a constitutional entity created by Article 5, Section 17, not by the legislature. Now, most of those provisions in the Constitution require enabling legislation. They're not self-executing or self-authorizing. But there is a grant of personal jurisdiction in Article 5, Section 17 to the Commission that probably is the floor, the irreducible floor of the Commission's personal jurisdiction. But its subject matter jurisdiction and all of its other powers must be pursuant to enabling legislation by the legislature. So from that bedrock principle that agencies are limited to the jurisdiction granted by statute, that means there's no jurisdiction for statutes outside of the statutes the legislature listed. So for example, if a complainant files an IPRA claim in the State Ethics Commission, there's no jurisdiction because we weren't giving jurisdiction, thankfully, over IPRA claims. Similarly, the State Ethics Commission Act says who's within the personal jurisdiction, and the legislature was careful to indicate that government officials and employees, state government officials and employees, are subject to the personal jurisdiction of the commission, but not the entities themselves. So, for example, whereas a board member or a commissioner of a state board or commission is subject to the personal jurisdiction of the commission, the board or the commission itself is not. And then similarly, touching on the question asked earlier, again, flowing from this bedrock principle, because the commission wasn't given jurisdiction over local public bodies or the officials or employees thereof, the commission doesn't have that jurisdiction. So complaints that file alleged claims of violations of statutes for which there's no subject matter jurisdiction that's not on the list in 1016G9A, this will be dismissed, as well as against entities for which there's no personal jurisdiction. So those are the inherent or the internal constraints on the commission's jurisdiction. Now flipping over to the external constraints on the commission's jurisdiction. There's two kinds of statutes of limitations. First, there's a hard bar that the commission has no jurisdiction over conduct that occurs before July 1, 2019. So there's not going to be any litigating of conduct that occurred in the Martinez administration or the Richardson administration, et cetera. The conduct that's the predicate of the alleged violation, it has to occur on or after July 1 of 2019 to trigger the commission's jurisdiction. Second, there's a 2-year statute of limitations. So the claim has to be filed in the commission 2 years after the date the conduct occurred, or could have been reasonably discovered. There's a kind of tolling provision here on that statute of limitations that will be familiar to many of you. And then last, there's a particular doctrine that will be helpful for the commission in making jurisdiction determinations and the executive director when making jurisdictional determinations, and that's the substantiality doctrine in the law of federal courts and the law of federal question jurisdiction. So there is a distinction that the Supreme Court has discussed between a claim's being so insubstantial or frivolous that it doesn't even trigger federal court jurisdiction and can be dismissed on kind of 12B1 grounds, as opposed to whether or not a claim states a claim for which relief can be granted and can be dismissed on 12B6 grounds. The analytical distinction there has kind of been under pressure in a number of cases, including in Bell v. Hood, which is a very seminal Supreme Court case about causes of action for constitutional violations. It's a kind of precursor to Bivens. But nevertheless, the idea that a claim can be so insubstantial as to not trigger federal court jurisdiction is a helpful one, and it enables the federal courts to dismiss claims that are filed in federal court that are so insubstantial that purport to raise federal questions and thus trigger federal jurisdiction. It's a way for the court to police its own jurisdiction In federal courts, this now seems to have its most strident application when a single judge is deciding whether or not to call a 3-judge court. There's some lawyers on the webinar that are senior enough to remember the days when any federal constitutional challenge to a state statute triggered a 3-judge federal court to review that constitutional claim. The 3-judge court statute has been pared back, and now essentially 3-judge courts, 3-judge federal courts, district courts only sit to review constitutional challenges to state apportionments or state redistricting. But this is the location in which this substantiality doctrine in federal courts arises. And it's helpful, I think, in the state administrative context and the ethics commission context. So for example, for a complainant that alleges a violation of the State Ethics Commission Act, whose duties are, as they apply to individuals, really only apply to the commissioners and staff and contractors with respect to confidentiality. But you can imagine a complainant filing a State Ethics Commission Act claim against another state agency because, for example, someone in that state agency was rude to them. For example, that's the kind of claim that purports to allege a statutory violation that's within the commission's jurisdiction, but it's really so insubstantial as to not trigger the commission's jurisdiction and to begin the wheels turning on the commission's process. There's no need for the commission to engage the hearing officer services of Justice Chavez to review that kind of claim in a motion to dismiss for failure to state a claim posture when it's really so insignificant that it's not going to trigger the commission's jurisdiction. So that's a brief review of the federal substantiality doctrine and how it can conveniently apply in the state administrative context. And then the last piece that I'll share with you, there's also the fact that several complaints that are filed with the commission at the moment will be referred. So you have to remember that the State Ethics Commission kind of dropped into a very populated legal ecosystem where the Secretary of State already had some enforcement and adjudication powers with respect to some of these statutes. Same with the state purchasing agent, the state purchasing division with respect to the procurement code. And so when the State Ethics Commission Act was enacted, it created the commission with shared jurisdiction. And in order to figure out that shared jurisdiction, very quickly the commission had to enter joint powers agreements with those other agencies to figure out how complaints that were filed with the commission would bounce back and forth between the agencies that had shared jurisdiction so that all of the statutory conditions are met. So for example, for a Campaign Reporting Act violation, the Secretary of State has an obligation to try to achieve voluntary compliance. And that needs to happen before the Ethics Commission would issue a remedy against a respondent. So there is a system of referrals under these JPAs, and in the next legislative session, the commission has to go forward to the legislature and propose a more streamlined version of these statutes for the legislature's consideration. Next, the Ethics Commission has no jurisdiction for criminal matters. If a complaint's filed that's very clearly alleges a violation of criminal law, that will be referred to the Attorney General's office or the appropriate district attorney, or in some cases, for example, if it raises a criminal violation relating to a federal election, for example, it would be referred to the U.S. Attorney's office. And finally, the commission also has the power to refer matters that are beyond its jurisdiction to an agency that has jurisdiction. A violation of the Human Rights Act is a very obvious example. But in any case of referral, the complainant and the respondent to the Ethics Commission is given notice. And with that, Walker, I'll hand it off to you, but I see that there's a number of Q&As popping up in case we need to answer any of them at the present moment. You're on mute, Walker. Unmute yourself.
Sorry, I had a little bit of delay there on the button. I think it may make sense to answer the question about what happens when the commission meets to dismiss a complaint for lack of jurisdiction or for failure to state a claim, which we'll get to later. Is the commission going to explain its rationale for dismissing the case in a open meeting? That's one question we've received.
In the open meeting, the commission will take a vote on the dismissal. The rationale by that point would have already been provided to the complainant for a jurisdictional dismissal in a letter from the executive director, which we're now styling as a notice of probable dismissal. I think it's, you know, at present, I'd have to go and look at the Open Meetings Act to see if there's a duty upon them to explain the rationale. But the order that comes out of those meetings, you know, is normally accompanied with a 1 or 2 sentence rationale. I suppose what I'm trying to land on here is there's going to be no shortage of public reason giving in the Ethics Commission.
So that, and I'll follow up with that by saying that one topic that isn't really being covered by this webinar is the various confidentiality provisions in the State Ethics Commission Act. And the commission has to juggle those provisions with its obligations under the Open Meetings Act. And so with respect to complaints before the commission, any complaint and matters related to the complaint or any alleged violation of the ethics laws is to be kept confidential unless and until the general counsel determines that the complaint is supported by probable cause. And so the commission has an affirmative duty under the State Ethics Commission Act to keep the materials related to the complaint confidential. However, as an attorney representing a complainant or a respondent, you as the attorney and also the complainant and the respondent are not subject to that confidentiality duty. And so that's why it's not covered in this webinar, because it doesn't really relate to your practice before the State Ethics Commission.
I appreciate that, Walker. And seeing some of these other questions, I'll just answer them quickly. So we have a question: Are the joint powers agreements entered into available to the public? They are. They're on the State Ethics Commission website. If you panel over to the law button, you can scroll down and find each of the joint powers agreements. Commissioner Villanueva asks, can a complainant refile dismissed claims? It depends on the kind of dismissal. So if it's a jurisdictional dismissal, ordinarily jurisdictional dismissals are without prejudice, and a complainant is always entitled to refile to try to cure a jurisdictional defect. For example, if a complainant files a complaint against an entity, not realizing that the commission has no jurisdiction for the entity, the complainant, if appropriate, can refile against a particular public official or public employee whose conduct they're complaining of. And we have an anonymous attendee asking on our position on whether or not jurisdiction should be expanded, and I would just say wait for the commission's recommendations to the legislature.
Okay, thank you, Jeremy. So now's my chance to jump in. I'm going to cover very briefly in the 15 minutes that remain in the general portion of the CLE, the investigation conducted by the general counsel after the executive director has determined that the State Ethics Commission has jurisdiction over the complaint. So I've got here a pull quote from the relevant section of the State Ethics Commission Act, and I've highlighted the relevant sentence there. If the executive director determines that the complaint is within the commission's jurisdiction, the director shall have the general counsel initiate an investigation. So the question is, what is the general counsel investigating? And the answer, again, is in the State Ethics Commission Act. Whether the complaint is frivolous or unsubstantiated on the one hand, or supported by probable cause on the other. So the question, I guess, most practical concern is, what does this investigation look like? And every complaint is going to be different. So I can't speak to what any investigation may look like. Some investigations may involve requests for documents, some investigations may involve interviews, some investigations may involve a mixture of both. So I can't really speak to what every investigation will look like. I will say that the general counsel's investigation is very likely going to start with talking to the complainant and the respondent to try and flesh out any allegations that are in the complaint that aren't yet supported by sufficient evidence, or talking to the respondent to try and determine evidence, or try and elicit evidence that the complainant may not have been able to provide in support of their complaint. So the State Ethics Commission Act really contemplates mandatory process only in one instance, which is a subpoena. I'm going to cover that very briefly in the course of my presentation. But first, I want to discuss something that Jeremy mentioned earlier, which is that the Commission's rules allow a respondent to file a motion to dismiss for failure to state a claim. This is a familiar procedural device in state courts. As many state court practitioners should know, they're looked on with disfavor. And I think the big case on this is Madrid versus Village of Chama, where the Court of Appeals expressly rejected the federal court's plausibility standard for motions to dismiss. So let me break that down to a little more simplified picture. Under federal law, federal courts look at a complaint as a whole and decide whether it's plausible, whether it's believable what the complaint is saying about the defendant. New Mexico state courts have said, we're not going to evaluate the merits of a claim. If no matter how outlandish the allegations in the complaint, so long as it states a claim for relief under New Mexico law, we will proceed to discovery in order to vet the claim and determine whether it's worthy of a jury trial. So the State Ethics Commission, being a creature of state law, has, I think, adopted the New Mexico court's approach to this. However, there is one caveat to that, and that's in the sub point there in the middle of the slide, which is the quote from Section 10E of the State Ethics Commission Act. The general counsel has an affirmative duty to conduct an investigation to determine whether the complaint is frivolous or unsubstantiated. And I think that indicates some intent by the legislature to require the general counsel to go beyond a kind of review of the sort of four corners of the complaint to determine whether it alleges a violation of a law within the commission's jurisdiction. And so as the commission's practice develops in this area, I fully expect motions to dismiss that raise sort of tricky questions with respect to the standard of review. But I will say that at least for now, the general counsel's standard of review for a motion to dismiss is at least as low or as lax as the New Mexico courts, and perhaps even lower. So that being said, on the other hand, the statutory section that I just quoted, Section 10E, does state that the general counsel must determine whether the complaint is frivolous or unsubstantiated, not whether the respondent has violated some law within the commission's jurisdiction. So again, that you're kind of navigating between two shoals here. On the one hand, there's an affirmative duty to investigate by the general counsel. On the other hand, the complaint is what is being investigated. And so the general counsel needs to have some kind of framework to work within in investigating a complaint before an investigation is going to occur. And so that all these matters are what are tested by a 12, I guess it's not a 12B6 motion, it's a 1.8.3.11 motion, but we'll call it 12B6 for familiarity's sake in this webinar. So I'm just going to take a brief look at these questions that are coming up here.
And Walker, while you do that, if I could elaborate a bit on this
Sure.
point of the standard. So another bedrock principle of agency administrative law is that agencies are bound by the rules that they promulgate. If an agency issues a rule and a rulemaking, it has to follow it. The rulemaking that the Ethics Commission did with respect to the adjudication of motions to dismiss for failure to state a claim for 12B6 motions, the general counsel reviews it, provides a recommendation, and that recommendation goes to the hearing officer, and the hearing officer makes the ruling. And because there's RMD counsel and risk contract counsel on the webinar, I do want to point out that there is room for briefing and argument in this area. That we would encourage briefing and argument about the proper standard that ought to be applied by this administrative agency when adjudicating these kinds of motions to dismiss for failure to state a claim. And ultimately, we could envision even that standard being the subject of an appeal to the full commission, and ultimately that being how the issue is liquidated. But this is still part of the gap. What's the standard that's going to apply for motions to dismiss for failure to state a claim? And it'll take some years in the commission and the cases that appear before it for that gap to be liquidated.
Thank you, Jeremy. So I've received some questions about the investigation process. I think I'm going to transition to the next slide to address that. First, I'm just going to quote from the statute. Under the State Ethics Commission Act, the General Counsel may administer oaths, interview witnesses, examine books, records, documents, and other evidence. As Jeremy's pointed out, we've fleshed out, the Commission has fleshed out that statute by setting forth a number of different devices for seeking discovery that the General Counsel can use. One question that we've received is whether interviews conducted by the General Counsel are on the record. That's an interesting question because I could see the General Counsel's investigation involving informal interviews where the General Counsel is talking to someone not under oath, and certainly that may inform the General Counsel's investigative choices. However, the State Ethics Commission Act requires interviews to be taken under oath, and the State Ethics Commission's rules require recording of those interviews. And so it may be a digital recording, it may be a court report or transcribed recording. The General Counsel's actual interviews under oath that will be used to determine whether a complaint is either frivolous or supported by probable cause will indeed be taken under oath and recorded. But to go back to the earlier point about confidentiality, before the State Ethics, the General Counsel determines that a complaint is supported by probable cause, these materials are confidential and not subject to public release. I would recommend that everyone who's got an interest in this area, you're attending the webinar, so I assume everyone does. Please read 1.8.3.11 NMAC and familiarize yourself with the contents, because not only does it set forth what the General Counsel can do to investigate as a complainant or as a respondent, it's going to show you what the General Counsel's investigation could potentially look like. And if you're a complainant, that means in your complaint or in correspondence with the General Counsel, you can propose approaches and say, here is the evidence will be found here. Please go this way. And a respondent can also read these provisions and determine the limits of the General Counsel's investigative authority. And that's what brings me to the next slide, which is, I think respondents may ask their attorneys, what are the, do I have to participate in this investigation? Do I have to respond to the document requests that I've received from the General Counsel? And certainly as a merits matter, the advice is you should, because the General Counsel is tasked with determining whether the complaint is supported by probable cause, and being forthright and providing evidence to the General Counsel from a respondent's perspective with good counsel should increase the likelihood of a dismissal before probable cause is found, and that will ensure that the complaint is not subject to public disclosure. It won't require a public hearing. So that's just the kind of global question. But in terms of rules of procedure, there are really only three potential consequences for refusing to participate. One is an adverse inference. The General Counsel can decide to take an adverse inference if a respondent or another party, a complainant as well, decides not to share information even after being requested to provide it. So in the case of a complaint that alleges probable violations of the law within the Commission's jurisdiction, and the General Counsel asks the respondent for evidence related to that allegation, and the respondent refuses to provide it, the General Counsel is permitted under the rules to basically resolve the issue against the respondent and make a finding of probable cause on that basis if appropriate. The second is the same provision of the State Ethics Commission's rules has a kind of borrowing from Rule 37 of the Rules of Civil Procedure for Federal Courts. A party who is in receipt of a request for documents from the general counsel and who does not provide that evidence cannot later use that evidence at a hearing. And that's, again, without a showing of good cause. And I guess the purpose behind that provision is to, again, encourage parties to be forthright in their pre-probable cause productions of documents. The State Ethics Commission and the parties don't want to be put through the process of having to present evidence to a hearing officer, hear witness testimony, and go through appeals if there's evidence out there that could be outcome determinative. And so the rules are designed to ensure that parties produce this evidence as early as possible in the process. Finally, section, the PowerPoint unfortunately has a typo, but section 10 and 1.8.3.11 C3 of the Commission's Rules of Procedure provide the general counsel with the ability to ask the executive director for a subpoena. And this process is somewhat convoluted, but what happens is upon receiving the request, the executive director must go before the commission, and the commission takes a vote on whether to issue the subpoena. Upon the commission's approval, the general counsel and the executive director will petition a designated district court judge. That judge is currently Judge James Martin in the 3rd Judicial District in Las Cruces, to hear the petition to issue a subpoena. Upon the judge's approval, the subpoena is issued, and then it is served by the commission on either the respondent, the complainant, or a third party. And then there may be some litigation in state district court over whether documents that are responsive to the subpoena are privileged or whether they're relevant to the general counsel's investigation. I will note, just as a practice pointer, Judge Martin is in Las Cruces. He is aware of how far away Las Cruces is from Albuquerque and Santa Fe, and he has expressed his amenability to conducting hearings by telephone. The commission has not yet petitioned for a subpoena, and so we haven't gone through this process yet, but there will be a specific case number assigned, and the administrative office of the courts has set up a kind of bespoke system for handling these subpoenas, and that's because all of those proceedings are sealed per the State Ethics Commission Act. Jeremy, do you have anything to add to that?
No, only that the next slide covers all of that. If anyone needs to refer
Sorry,
back
I should have toggled that over. So I'll cover the relevancy point a little more. Section 10J says that a subpoena must seek information that is reasonably related to an investigation. So a party answering a subpoena could potentially challenge one based on whether it's related to an investigation. However, that standard is pretty loose, and I would expect that a relevancy challenge to a subpoena at the initial stage of a general counsel investigation would not be sort of receptively taken by the designated judge. The more interesting question will be privilege points, which may come up from time to time, especially, I mean, I think when the commission is seeking a subpoena, I think it can be kind of assumed that the party receiving the subpoena has already refused to provide information. And so there could be significant litigation in this area. So please see 1.8.3.11 C3 for additional details about the subpoena process. Finally, I'll very briefly cover this. I touched on it earlier. The investigation process before the general counsel is a kind of hybrid adversarial and inquisitorial system. Ultimately, the complaint is the sort of frames the issues and determines what the general counsel's investigation is going to be. But also the general counsel is the one who determines probable cause, not the complainant, not the respondent. And because this process is confidential by statute, the general counsel's investigation is going to be ex parte at times. Parties may not receive information. It's not like civil discovery where all parties are going to be served with copies of everyone's responses to requests for production. The general counsel may ask a party to provide evidence. The party may provide evidence, and only when the general counsel determines that a complaint is sort of supported by probable cause will that evidence necessarily be shared with other parties to a complaint and the public? So finally, the final point to cover in this area is that the general counsel's finding that a complaint lacks probable cause is final and unreviewable. That the hearing officer who receives a report that a complaint lacks probable cause, this is after a general counsel investigation, is required to dismiss. Does not have the same potential discretion that would be present for a Rule 12b6 motion to dismiss for failure to state a claim. Finally, we'll go to hearings. If the general counsel determines that a complaint is supported by probable cause, the report on the complaint, which is prepared by the general counsel, goes to a hearing officer and the parties. The hearing officer sets a public hearing, and then from that point on, the State Ethics Commission Act kind of contemplates the parties taking over and examining witnesses, presenting evidence, and otherwise basically running the show like a sort of bench trial in front of the hearing officer. So the one quirk here is that the parties can ask the executive director to compel the attendance of witnesses. This is an interesting point. I haven't really thought this through, but the statute at least raises the possibility that the executive director has some power to compel the attendance of witnesses that does not need to be ratified by the commission itself. But the parties in preparing for a hearing will need to go through that process, determining which witnesses to present, which witnesses need to be compelled to present to attend. Again, this should be familiar from reading the State Ethics Commission Act. The rules of evidence apply, and the sort of normal civil standard of proof, preponderance of the evidence is what determines the hearing officer's decision. And for fraudulent and willful misconduct, clear and convincing proof is required, again, like civil cases. So I would refer listeners to 1.8.3.13 NMAC for a more detailed overview of the hearing process. Finally, I'll just very briefly cover appeals before we go to the ethics portion of the webinar. Parties can appeal a hearing officer's decision to the full commission. And a hearing officer, again, after a hearing, will issue a finding of fact and conclusion of law as to whether or not the respondent violated the law as alleged in the complaint. That decision may be appealed to the full commission, which will sit in a public hearing, public meeting, and address the appeal. I don't have enough time to go over the specifics of the appellate process, but 1.8.3.14 NMAC sets out the procedure, including a 10-page brief limit. So that may be challenging for some lawyers, but it's necessary for the commission's appellate efficiency, I think. So again, as Jeremy mentioned early on in the presentation, the commission rules permit certiorari review by district courts under Rule 175 NMRA.
So Walker, before we go to the ethics part, we have an interesting question about a party being able to move to disqualify a hearing officer or a board member, a commission member. With respect to the commission members, I point the person who asked that question and the other members of the webinar to the rule 1.8.2 in MAC, which is the rule that governs recusal and disqualification of the ethics commissioners. With respect to a hearing officer, that's another gap in the rules of procedure. There's no black letter rule on a motion to disqualify a hearing officer. If you're a litigant who finds yourself in that position, I think you file a motion with the commission at the juncture at which probable cause, the general counsel would have determined probable cause, and a hearing officer would be called in. But again, that's a gap that we'll have to work through the course of cases that come before the commission.
Thank you. Let's proceed to the ethics module so we can get that 0.5 credit for everyone. I'm going to sort of be on a team with Jeremy for these slides. I'm going to cover the pros and cons of advising a client who wants to file an ethics complaint. And the pros and cons really are here to whether to advise your client that they should indeed file a complaint. The pros really, the process is fast. The State Ethics Commission Act contemplates a final resolution of a ethics complaint within 90 days of the filing of the complaint. The State Ethics Commission Act requires the commission staff to go before the commission and justify why a complaint has taken more than 90 days to resolve. And so the commission staff work very hard to ensure that complaints are resolved and investigated quickly. In the ordinary course, a hearing probably will not take place within that 90-day time frame, but it's certainly our expectation and the goal we work towards in every complaint to have the complaint resolved either on pre-investigation motions or through an investigation that results in a recommendation that a hearing be scheduled within 90 days. Second, the complaint alleging ethics violations can state claims under different statutes that really aren't available to litigants in state court. So the Campaign Reporting Act, the Financial Disclosure Act, Governmental Conduct Act, all those statutes do not create a private cause of action, private right of action, except I guess arguably through the declaratory judgment statutes. But that's just an aside. The point here is that if your client suspects official misconduct, the sort of universe of potential causes of action expands when you're before the State Ethics Commission. Finally, the sort of economics of litigating are a little more favorable, and that's just because the State Ethics Commission Act assigns the burden of both service of process and discovery to the commission staff. So although certainly litigating before the commission will require the attention and time of lawyers who are involved, the commission has been tasked with doing the investigation, interviewing witnesses, soliciting documents, et cetera. And so especially if you're on the complainant side, it's a little bit less costly from both a time and potentially monetary perspective to litigate in front of the State Ethics Commission. That all being said, the chief con to proceeding before the State Ethics Commission is the lack of any compensatory remedies. The remedies under these statutes are all kind of civil penalty type remedies, and the State Ethics Commission doesn't have the power to award civil damages that would be available in state court. And in addition, there's no attorney fee shifting provision so that a prevailing complainant would be entitled to attorney fees if they prevail before a hearing officer. So those are the main pros and cons. And in advising your client about whether to proceed, that's sort of what needs to be in your mind about whether it makes sense to advise them to file a complaint with the Ethics Commission. So that's that. I'll turn this second portion over to you, Jeremy.
Thanks, Walker. Two other topics to bear in mind when you're advising a client on whether or not to file an ethics complaint or an administrative complaint with the Ethics Commission is how the doctrine of exhaustion of administrative remedies works in New Mexico, and also the potential preclusive effect of State Ethics Commission, hearing officer or full commission findings or orders. So I'll take those in reverse order because it conceptually makes more sense. At least from the case law, the state courts are less reluctant to apply the doctrine of exhaustion of administrative remedies than the federal courts are. And I think what that basically means is that if you have a client who has a claim, a Governmental Conduct Act claim, for example, and you want to file that in the form of a declaratory judgment action in state court, it's unlikely that the defendant can dismiss you for failure to exhaust your remedy in the State Ethics Commission because the Ethics Commission has jurisdiction for the Substantive Governmental Conduct Act claim. The only case in which that kind of defense would work, I believe, if your client has already started a case in the State Ethics Commission and the proceeding is pending on, for example, a Governmental Conduct Act, and then while the administrative proceeding is pending, you go and file in state court a declaratory judgment action. That's likely to be subject to a dismissal based on the doctrine of administrative remedies under the Baca case, and I think New Energy Economy versus Shoebridge has a similar point. So you don't have to start in the State Ethics Commission, but if you start in the State Ethics Commission, you're going to have to wrap it up there. Similarly, if you do file a claim in this, if your client files a claim in the State Ethics Commission, you need to be aware that there's potentially a preclusive effect, both a res judicata and a collateral estoppel or a issue preclusion effect of a hearing officer or a commission finding as a matter of fact or orders as a matter of law that a court might apply in a subsequent proceeding. That's all kind of speculative at the moment. We'll have to see how the courts interact with the Ethics Commission proceedings over the course of years to come. But that's at least now how the doctrine exists in New Mexico case law, and my best guess is how it would apply.
Thanks, Jeremy. So turning to the question of what kind of ethical issues might present themselves to a lawyer who's representing a potential complainant. Really, the main issue here is the difference between what a complainant has to do in order to get a complaint before the commission versus what a complainant has to do, or what a plaintiff has to do to file a complaint in district court. Under the State Ethics Commission Act, Section 2D, by filing a complaint with the State Ethics Commission, the complainant, the person who signed the complaint and got it notarized, is affirming under penalty of perjury that the information in the complaint and any attachments provided with the complaint are true and accurate. And that is a more stringent and exacting standard than the standard set forth in Rule 11, which basically permits an attorney to file a complaint in district court on behalf of their client that really is only supported by a good faith belief that the complaint's contents are true. And so, I mean, there's no end to the debate and discussion about what the real standard is for Rule 11, but suffice it to say, the standard under the State Ethics Commission Act is much more stringent. And so that has a couple of implications for the lawyer representing a complainant. As a practical matter, it means that you should have your client sign the complaint. It is your client's allegations as to the truth of the complaint, and it is your client who is going to be the one swearing to the truth of those allegations. You as a lawyer, I think, are rarely going to be in a position to be able to say, to the same extent as your client, that the allegations contained in the complaint are true and accurate under penalty of perjury. So, just as a practical matter, it means that you will have to have your client. Your client will be the one who needs to sign the complaint and get it notarized, not you. And then this also has a kind of background implication for the lawyer as a necessary witness rule. Again, just to provide further support to the point that you should not be signing an ethics complaint filed on behalf of someone else, is that if you, the lawyer, sign it, you are basically declaring yourself to be the complainant, and that means that you are going to be one half of the focus of the general counsel's investigation, and also you're going to be a necessary witness at any hearing on the complaint. And so, really, it just underscored that there is a kind of difference between what kind of process has to take place before your client files a complaint with the State Ethics Commission. And I guess the essential point is just that your client needs to be the one who signs it. Oh, wrong way.
So Walker, before we leave that slide, I think it's worth mentioning also the requirement that a complainant have actual knowledge in order to file that complaint. So that's a statutory requirement under 1016G 10A. The the meaning of the actual knowledge requirement has been discussed before the commission when the rules were being promulgated. And as of right now, the commission and the staff don't interpret that actual knowledge requirement to entail personal firsthand knowledge. So that more stringent condition I don't think is borne out by the text or what the legislature intended. So it's the knowledge requirement that a complainant has to have to file a complaint before the commission, and I suppose to sign it under the these conditions that are provided for in section 2D, which is the definitional section for complaints. Again, the complainant need not have actual firsthand personal knowledge of the violation in order to have actual knowledge, which permits them to file the claim. Anything to add there, Walker?
Yeah, that's a great. I'm really glad you brought that up, Jeremy. Early on in the process, when the commission was adopting rules of procedure, this issue came up a couple of times about what exactly it takes for a complainant to have actual knowledge of the alleged violations of law here. And the commission staff did some research on this issue, and the New Mexico courts have taken a not very stringent view of that phrase. Actual knowledge just means that you really have knowledge. Actual is not doing too much work in that phrase. And so if that knowledge is secondhand or thirdhand, that's fine. That doesn't mean that it's not actual knowledge anymore. And so really the requirement that a complaint be sworn to be true and accurate goes to just what's in the complaint. So if the complaint itself alleges that I've heard from someone else that the respondent is violating the Governmental Conduct Act, that's fine, because you're alleging that it is true and accurate that you heard from someone else that the respondent violated the Governmental Conduct Act. And the actual knowledge requirement, I guess, could be the subject of some litigation in that example, but at least from sitting here and from our perspective, the standard is loose and designed to be pretty easy to satisfy for a complaint.
Okay, I'll take this slide. And since there are a lot of agency counsel on the webinar and risk management and risk contract counsel, we put some time into thinking about how some ethical issues might arise, professional responsibility issues might arise when representing respondents before the commission in an administrative case. The first and most important thing to remember, if you're an agency counsel, if you're in a general counsel's office at an agency, if an employee of the agency comes to you with an ethics complaint that's been filed against them, you need to bear in mind that particular person, that respondent, might be entitled to risk management appointed counsel, and that's a statutory entitlement under 1016G 10K. Ultimately, it's not the State Ethics Commission's call, it's Risk Management Division's call on when they're going to assign risk counsel and how they read that particular statute. But the statutory provision is, if the complaint alleges a violation made in that respondent's performance of their duties, then the respondent is entitled to risk counsel. So, for example, how that might play out, an elected official doesn't have a legal duty to seek elected office again. And so if the complaint touches on or alleges a violation of the Campaign Reporting Act, for example, against that particular elected official, that might be an instance in where risk management would decline providing risk contract counsel to that elected official in that kind of case. But in your run-of-the-mill procurement code or Governmental Conduct Act case, that's a more likely candidate for risk management to assign contract counsel. But either way, if you're the agency's counsel or in a GC's office at an agency, and again, an employee comes to you and they've been named as a respondent, you need to remember that you can advise them that they can go to risk management. And if the Ethics Commission is doing its job correctly, when the commission sent that employee the complaint, we will have also provided with them with a letter from risk management to the same effect. So the another idea is that it's very possible that agencies will get cases or will see cases where the complainant and the respondent are both employees of the same agency, particularly if it's a large agency, and there's kind of the insider knowledge about how the procurement code and procurement has been taking place, or what's going on that might implicate the Governmental Conduct Act. It's likely that there will arise cases where the complainant and the respondent are both employees of the same agency or both affiliated with the same agency. And in that case, the agency counsel really ought to point the respondent to risk counsel so they avoid a conflict or the appearance of a conflict. We also have kind of thought about the likely to occur Governmental Conduct Act type claims or procurement code type claims. I think for any of those claims, if you're the agency counsel, it's advisable to point the respondent toward risk management. And that comes up as a kind of logical consequence of a few things. The first is, as the agency's lawyer, your first duty is to the agency, to the organization. And you don't want to get in a position where you're adverse to the agency, or your position is somehow adverse to the agency. And this might particularly arise depending on how and whether a Governmental Conduct Act or a procurement code claim is characterized by a future court or future case as an individual capacity or personal capacity, or a organizational or official capacity suit. So let me briefly touch on the distinction between a personal capacity and an official capacity suit. So for those lawyers, those in the trial lawyers, those on risk counsel, that's more lawyers that are more aligned with the defense bar, you will both recognize this distinction from Section 1983 cases. The theory of Section 1983 is that it creates personal capacity lawsuits where the individual state agent is personally liable, for the plaintiff's damages out of their own bank account. Now that kind of personal capacity aspect of 1983, it's modified somewhat by the existence of the qualified immunity doctrine, and also by the insurance contracts that public agencies have, for suits against their employees. But at bottom, 1983 actions are personal capacity actions, except for Monell type actions, which are official capacity actions. And if you want to explore that kind of distinction in federal 1983 law, Kentucky v. Graham, which we provided here, kind of provides a nice quick explanation of it. That distinction came up in the New Mexico Supreme Court in Flores v. Herrera a few years back, where the court held that a Whistleblower Protection Act claim is not an individual capacity claim, it's an official capacity claim. And so that's all the kind of the workup for the potential conflict you could get yourself into as agency counsel. If the courts were to extend the ruling of Flores v. Herrera to the Governmental Conduct Act or the Procurement Code, such that those claims are not individual capacity claims, but official capacity claims, such that the agencies have to pay for the civil penalties, which would be odd, but possible. You would be in the position of arguing for your client, the agency, that they ought to be personal capacity claims. But if you're arguing that they ought to be personal capacity claims, or they're best construed as personal or individual capacity claims, that's directly contrary to the respondent's interests. So in a Governmental Conduct Act or a Procurement Code case, where I think that there might be some room for debate, given Flores v. Herrera, and whether or not its rationale can be extended to other kinds of statutes, if you're an agency lawyer, you don't want to be in that position where you're representing the respondent, but need to take a position on that question of personal or official capacity that's somehow contrary to your agency. The statutes for which the commission has subject matter jurisdiction over, some of them clearly create individual capacity actions, like the Campaign Reporting Act, for example. There's no real conceptual way in which that creates an official capacity action. A violation of the Campaign Reporting Act, the candidate is on the hook personally. Alternatively, and completely separately, an anti-donation clause violation seems to me to be only possible as an official capacity claim. If someone files a claim that the anti-donation clause was violated, well, the remedy for a violation of the anti-donation clause is a restitutionary remedy. The state has to give it back, and in the Constitution, the anti-donation clause refers to the state or a local public entity. It's clear that the restitution has to. I'm sorry, I flipped this around. It's clear that because it's restitutionary, whoever is the recipient of the funds, they will be liable for the restitutionary remedy. But for a governmental conduct act or a procurement code claim, I think it's unclear whether or not Flores v. Herrera would extend to those also being official capacity claims. And so the bottom line is, for those kinds of claims, you want to go to risk management counsel. And Walker, that's what I have on issues that might arise from a professional responsibility context for respondents.
One more thing, Jeremy, for agency counsel to think about, and this actually applies more broadly to all litigants, is that there is a process for settlement of State Ethics Commission complaints. The general counsel, either during the investigation stage or before the hearing, can elect to enter into a settlement agreement with the respondent. The settlement agreement has to become public, and the complaint as well. That goes to the sort of confidentiality provisions of the State Ethics Commission Act. But both in settlement and in the hearing itself, there are issues of remedies in terms of what is going to be, what's the appropriate remedy for a violation if a violation is found. And I can certainly anticipate situations where an organization's interests may point towards settlement of some kind and be in conflict with the constituent who's being represented by agency counsel. So this again, there are some new and still yet to be fleshed out ethics issues with agency counsel who are faced with, who have been given an ethics complaint that's been filed against a colleague, and are deciding whether they can enter an appearance on behalf of this colleague, or whether the rules of professional conduct would bar that kind of appearance. So I think we're right at about our time here. We have 3 open questions. Mr. Resnick asked a question about that I think I addressed earlier, about whether investigative interviews are recorded or transcribed. But he asked a follow-up question about whether investigative documents are considered privileged or work product. Certainly, there are going to be work products and privilege issues that are going to arise for communications that are going between the executive director and the general counsel, or between commissioners and the executive director. When it comes to potentially adverse witnesses, there may be work product issues, but more generally, I think the State Ethics Commission Act kind of issues a kind of blanket confidentiality over pre-probable cause investigative materials that's going to kind of preempt any work product analysis, because the commission is just under a duty pre-probable cause not to release any materials related to a complaint. So again, whether that goes to whether an individual party is going to be provided with information in a case is just going to depend on the facts of the case. The general counsel may be investigating a case and need to get the respondent to answer discovery that was provided by the complainant or a third party, and that would be disclosure of evidence that was gathered in the investigation. And the State Ethics Commission Act itself provides for that power to the general counsel. The general counsel can provide information to third parties in pursuit of an investigation. So that's that question. We've got a couple of questions about the materials. I've answered one in writing earlier, but we received another question about CLE materials. Those have been put on the website, the PDF that contains the agenda and the NMAC provisions of the State Ethics Commission Act. That's on the website. The PowerPoint will be provided to attendees either by email or be posted on the website. One way or the other, we'll get everyone a copy of the PowerPoint slides. Let's see here. Someone's asking a meta question about questions, which is, can we see the other questions? And unfortunately, my Zoom expertise does not extend that far, Ms. Sabo. So oh, I see. I have to press a button here. So I'll answer live the meta question. I think everyone should be able to see Kathleen's question about being able to see other questions. I apologize. I didn't realize that I had to leave that toggled before answering the question. So finally, let's see here. We received a question from Commissioner Villanueva about the process for withdrawing a complaint. Can the complainant withdraw at any point? Jeremy, I think
the answer to that question, is yes, but it's a little complicated because the rule provides for the general counsel to intervene in a hearing, particularly in cases where the complainant is a pro se complainant and has gotten all the way to a hearing. If the general counsel has intervened, I think that the case would continue, but there is a rule that allows for voluntary dismissals from the complainant. But again, if the general counsel has intervened in the hearing at that point, I don't think the case ends.
Thank you. We've received a question from Dan Dolan. If a vote of the Ethics Commission does not address one element of the complaint, would a party be able to ask the commission at the open hearing on the vote about why that argument complaint was rejected? Again, to go back earlier, the parties to a complaint are not bound by the confidentiality provisions of the State Ethics Commission Act. And so if a party elects to attend a commission meeting where it considers the dismissal of a complaint, the party would be able to address that during the comment section of the meeting. Is that correct, Jeremy?
That's right.
Thank you, Mr. Dolan. Finally, from Commissioner Villanueva, again, is the SEC General Counsel permitted to perform co-investigations with agencies it has the Ethics Commission has joint powers agreements with, such as the Secretary of State? That's a good question, Commissioner Villanueva. The State Ethics Commission Act, I think, contemplates joint investigations. However, it does not require the State Ethics Commission to cooperate or work with another agency in investigating potential violations of the law. So whether agencies cooperated in a given investigation would, I think, be up to the discretion of the cooperating agencies.
And the way that works under the JPAs is that if a referral leaves the commission, goes to, for example, the Secretary of State, and then comes back to the commission, they send it back with the materials that they've accumulated so far. So in practice, the answer is that investigatory materials, I suppose, are jointly produced.
Thank you. Finally, we've got a question going to what happens if a complaint is withdrawn, and what happens to that complaint. The Commission's rules of procedure do contemplate the General Counsel intervening in a case and prosecuting a case. That's kind of an exception rather than the rule, and it would kind of depend on the facts and circumstances of a given case. Certainly, one factor to consider would be whether a complainant had withdrawn the complaint for some improper reason. All right, I think we've answered those questions in rapid fire. We're already 7 minutes over, folks. Thank you all for attending this webinar. It's our first, hopefully, of many webinars. We're trying to we're taking the Ethics Commission's statutory duty to provide ethics trainings for folks who have a stake in its jurisdiction and its work, and we very much appreciate everyone's attendance. So with that, Jeremy, do you have any final words? Otherwise, we'll sign off.
None other than that. Thank you very much, and stay tuned, and please continue to follow our work.
Thank you.